Major changes for foreign workers in Canada. In today's video update, we will talk about the upcoming changes by Canadian government in the temporary foreign worker regulations. Tougher rules for employers and more safeties for employees could be approaching. The Canadian government is suggesting major changes to rules for temporary foreign workers. It is known that temporary workers come to Canada under one of two paths. The first is the Temporary Foreign Worker Program. This visa stream is for businesses who want to employ non-Canadians for jobs that Canadian citizens or permanent residents are reluctant to do. The other is the International Mobility Program. This visa route lets foreigners to work in Canada at jobs even where there might be a Canadian national is available to do the job. The big difference between a job under the Temporary Foreign Worker Program and one under the International Mobility Program is that the Temporary Foreign Worker Program obligates an LMIA but the International Mobility Program does not. LMIA is an abbreviation for Labour Market Impact Assessment. It is a form which a companies looking to hire through Temporary Foreign Worker Program completes. It demonstrates that the employer tried to, but could not, find a Canadian to take the job. Recently, employees raised concerns in talks. Especially, they noticed temporary foreign workers time and again not capable to understand and use their rights. Major problems included employers formally found to be non-compliant with regulations avoiding prohibitions on hiring temporary foreign workers. Such employers do so by employing via other companies they own. Temporary foreign workers not aware of their rights or what they signify. Temporary foreign workers not having appropriate access to health care. Temporary foreign workers being charged unlawful recruiting fees by recruiters or employers. Temporary foreign workers afraid of employer revenge if they bring up concerns about working conditions. These anxieties have caused employees to not report ill treatment. Being a temporary foreign worker in a new country and culture can make one helpless. Consequently, Canada has decided to improve the protections for temporary foreign workers. The government plans the following changes: obligating all employers of temporary foreign workers to provide to each temporary foreign worker a paper document that summarizes temporary foreign worker rights. Employers would also have to display this information in a public spot in the workplace. Obligating all employers to give an employment contract to both the worker and the government. This document affirms that the employee will be working in the same job, working conditions, and salaries as mentioned in the employment offer. Making clear that the employer gives a workplace free of mistreatment. Retaliation is also considered abuse. Permitting Employment and Social Development Canada to stop processing of a labour market impact assessment if it believes the employer has not been compliant with the regulations. Creating new obligations for allotting labour market impact assessments. These will include taking sufficient efforts that the workplace is free of abuse, demonstrating that the employer respects all federal and provincial employment rules, and not permitting an affiliate or alter ego of an ineligible employer to hire temporary foreign workers. Decreasing the time an employer has to reply to a notice of preliminary findings from 30 days to 15. A notice of preliminary findings specifies non-compliance affairs. A decreased reply time will permit quicker resolution. Narrowing the ban and penalty on employers and recruiters charging temporary foreign workers illegal recruiting fees. Giving Employment and Social Development Canada and IRCC the authority to demand documents from third parties, for example banks, to confirm employer compliance. Obligating employers to make rational efforts to offer access to health care to employees who become sick or injured at work. An example might be setting up a phone at the workplace for temporary foreign workers to call health services. Obligating all employers under the Temporary Foreign Worker Program to pay for and give employees private health insurance. This insurance need to include emergency medical care. Currently, some temporary foreign worker programs are not obligated to give such protection. The Government of Canada accepts that the new rules may impose greater costs on business. On the other hand, outlays are anticipated to be minimal. For instance, an additional 10 minutes to give the employment agreement and working conditions to each temporary foreign worker. The advantages will be greater transparency for employers, employees, and the Canadian government. Temporary foreign workers, in particular, will enjoy stronger protections. Our video ends here. Please don't forget to support us by commenting below and subscribe to our channel to get the latest updates on UK visa and immigration. Thanks for watching.